Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to talk about the tax language that you're going to want to have in your divorce agreement or proposed orders to a judge if you're having a trial. The easiest way to go over this is to share my screen. So let's look at that language together. Um, First, you're going to want to have language that deals with the actual filing of the tax return. So if you are divorced prior to the end of the year, prior to December 31st in any given year, you cannot file a joint tax return for that year. You have to file separately. However, if you're married through the end of a year and your divorce isn't until the following year, you can file a joint tax return for the year in which you were married through the end of the year. So first, so here's some sample language. So the party shall file a joint tax return for for a particular year. So again, you can only put that language in if you're referring to a year that is prior to when this divorce agreement is finalized. So if you're getting divorced in 2023, if you write this agreement up in January of 2023, then this would be filing a joint tax return for 2022, presumably. But if you're getting divorced in 2023, you can't put 2023 because the IRS doesn't allow you to file a joint return. So you might put in your agreement, the party shall file a joint tax return for, whatever year, and the parties shall be equally entitled to / responsible for any refund and or debt. So you might want to put this in, but you don't have to. The agreement might say that the parties are going to file separate tax returns, and you can only have the agreement call for filing joint taxes if both parties want to file a joint tax return. The court doesn't have the authority to order people to file a joint tax return unless they agree to do so. So for that reason, there has to be an agreement for there to be any language for a joint filing. And then again, this doesn't have to be an equal division of the refund or debt. You might want to allocate the refund or tax debt differently, 75-25, or you can allocate those funds however you want. And then you'll usually say that the party shall file a separate tax returns for the year that the divorce takes place and each year thereafter, because you can't file a joint tax return. And normally in that situation, the parties are solely entitled to or responsible for their own refund or debt. So that's the actual filing of the returns. And then often you're going to need to deal with real estate deductions if the parties own real estate. So you're going to need to allocate who gets to claim those deductions. So you might say the parties shall each claim 50% of the deductions on for a given year. But if one party is keeping the house, for example, let's say in this situation, the wife is keeping the house and you're getting divorced in early 2023. You might say, okay, the parties shall each claim 50% of the deductions associated with the house in 2022, but the wife's keeping the house. So in 2023 and each year thereafter, the wife gets 100% of the deductions associated with the house because she's going to be paying the expenses associated with that house if she's keeping it. And again, you can adjust this language however you want. If the house is being sold, you might say, that the parties equally divide the deductions until the property is sold. So you can tailor that language however you would like. Then you're going to need to deal with claiming dependency exemptions and or child tax credits for children. So the standard is for when there are an even number of children for the parties to each claim one, or when there's an odd number of children for the parties to alternate on a year-to-year basis for the parties to alternate claiming the extra child. So standard language when there is one child is that the party shall alternate claiming the dependency exemption and or child tax credit for the minor child, with the mother having even numbered tax years and the father having odd numbered tax years. If you have two children, you might say the party shall each claim the dependency exemption and or child tax credit for one of the children. But when there is only one child to claim, the party shall alternate, with the mother having even numbered tax years and the father having odd numbered tax years. Then three or more children, you might put in language that says when there are an odd number of children to claim, because you might have three or more children when the agreement is entered into, but as the kids age out, it might go down to two kids and then down to one kid and then get down to none. So in any calendar year, when there are an odd number of children to claim the dependency exemption and or child tax credit, the mother shall claim one more child than the father on even numbered tax years, and the father shall claim one more child than the mother on odd numbered tax years. And then when there are an even number of children to claim, the party shall claim an equal number of children. So again, this is kind of alternating that extra when there are an odd number of kids. So that's the standard language. Again, you don't have to do it that way. You might have one parent claiming, if there's one child, one parent might claim that child every year. Or, if there's multiple kids, you might have one parent claiming that child every year. Or if there's two kids, you might say, one parent always claims one child and the other parent always claims the other child, and there's never a circumstance of alternating. So again, this language can be tailored however you would like. So those are the basics of the tax language in a divorce agreement. And if you have any other questions, feel free to contact our office at any time.